Oh, let's see here. So I did a little short video the other day about mortgages, loans, the IRS Form 1098, and it's stirred up a lot of good conversation, which is always great, which naturally leads to a lot of questions, and questions are good. There is no bad question. I don't care how ignorant the question may seem or may appear, or how far out there the question may be. Questions are good. That's how people learn. And so one of the questions was asked, like, I'm still getting these statements even after foreclosure from the bank. They're actually sending me the 1098s every month or every year, every quarter. They're sending me a 1098, Derek. What exactly does that mean? Well, it's like this. You never really own the real estate and property, okay? You're just a tenant on it, okay? Through what I perceive to be an unlawful conversion. And again, Mr. Anonymous chews my ass for drawing conclusions, but when you read as much as I do and as much as many others do, you start to be able to draw these inferences, these conclusions from what you're seeing, okay? It's a system that has repeated itself for thousands of years over and over and over again. The unmistakable pattern, it's a chronic pattern at this point, is theft through conversion. Unlawful conversion is what I would call it. Some people say it's illegal. Some people say it's fraud. I would venture to say that it's theft through an unlawful conversion, all right? First and foremost, you're told that you're going to buy some real estate and property. Keep in mind that you can't buy land because land cannot be bought or sold. And you're led to believe that you are going to be a purchaser, that you're going to buy this real estate and property. But that is not, in fact, what actually happens. It's completely on the opposite side of the spectrum of what actually happens. What actually happens is you go into it with clean hands, pure intent, enter into a contract. There's some third-party interveners that get thrown into the mix, whether that be the title insurance company, the real estate broker, as well as the bank. And then after some paperwork is shuffled, I call it the 3-card shuffle. Can you find the red ace? Can you find the red ace? Can you find the red ace? And you pick the card, and lo and behold, it's a black ace of spades. It's not the red ace of hearts that you're supposed to be paying acute attention to detail to. What do I mean by that? Well, you sign all your documents in your full legal name, first, middle, and last name. You initial where you need to initial, and you follow these steps and these protocols through the mortgage and the UCC1 financing statement. It's a financing statement. I'm tired of hearing people run around going, it's a UCC1 lien. It is not a lien until there is a judgment behind it, and you can secure that judgment with a UCC1 financing statement, and you can attach that obligation to a debtor. Now you've securitized the lien. Now you have fucking created money, essentially, and you can negotiate that instrument with banks, the International Bank of Settlements. You could sell it to somebody. People will buy that shit all fucking day long. Why? Because it is in the banking industry is what is called a securitized lien, because there is an obligor who has a duty to pay. Okay, and that's what creates a securitized lien. A UCC1 financing statement does not create a lien. It merely shows that you have a purported interest in said property or thing that has been manifested into existence. All right. So where's the first downfall? Well, the way that I see it, the first thing that ever happens when you go to the bank after you've found the realtor, the first thing that I would draw attention to, and this is something Mr. Anonymous bestowed upon me. He said, Derek, check this out, buddy. When you go in, anytime you go into a dealership, into a mortgage situation, what is the first thing you notice? And I had to think for a minute. I was a little perplexed by his question, Some of the real estate investments I've been involved in didn't really go the way that most people conduct their business in the 21st century. So I was kind of out of the loop. And I said, well, help me out here because I really haven't done anything traditionally per se. And he said, okay, well, the first thing that happens is you'll notice that everything is in-house. Isn't that amazing? Everything is in-house. They've got witnesses there for you. They've got a notary present and on deck and on hand. They've got all the documentation ready for you. It is all in-house. You don't have to leave. They make it so abundantly convenient. They will even go out and get you a steak fucking dinner and bring it to the fucking bank if you ask. They'll do those things. They will accommodate you. You could ask for them to bring a bouncy house so your kids can play out in the street in a bouncy house while you sign all these documents. They will accommodate you. It's not an exaggeration, and there's a reason why they will accommodate you, okay? And it wasn't until Mr. Anonymous drew this to my attention that I realized what they were really doing. He says, now, when you get these documents, instead of signing everything right there, instead of bending to their whim, which seems to be very, very convenient, and for most people, it is extraordinarily convenient. Most people just want to get the keys and go to this new humble abode and move in and claim that they own a house, all right? You have to understand, when they are making things so convenient, you just can't fucking refuse. Have you ever heard the saying, it's too good to be true? Have you ever heard this maxim used before? Seeking counsel after the fact is always in vain. Okay, after the deed is done, seeking counsel is frivolous because you've already committed to something. Okay, so you did something in ignorance because for hundreds of years, your lineage from past generations have done the same thing repetitiously. They've never studied the law. They've always done what they were told, and that is a downfall. All right. So instead of just signing all those documents, you say, hey, why don't you go ahead and give me the promissory note? Why don't you go ahead and give me the mortgage package? And I'm going to take it under advisement. I'm going to seek the advice of counsel. And I'm going to review all this. We've already locked in a number. We've already made sure that everything's going to work for everybody. But before I sign all these documents, I really need the time to read them, to comprehend them, and to review them with my counsel. Okay, now this gives you a great opportunity to do a number of things that will help you down the road in the event that they should try to foreclose on you or allege somehow that you're delinquent and that there's arrearages or anything else. Okay, first of all, we should never sign anything we don't read. Secondly, we shouldn't sign anything we don't understand. If you don't understand it, you are subjecting yourself possibly to something that could be very, very damning and harmful, not only to you, but your offspring, your mate, your esposa, whatever, okay? So it was what he was telling me made a lot of sense, and it was because I understood some maxims of law that it made even more sense to me. He says, now, what's the first thing you're going to do when you take all these documents home? What are you going to do? I said, well, fuck, naturally, I'm going to read them. Then I'm probably going to call Mr. Anonymous. I'm probably going to scan him in, send him over to Mr. Anonymous for review as well, because he's a brilliant legal mind, right? So why wouldn't I follow my own instructions, right? My own advice. Seek counsel. Seek somebody who's competent. It doesn't necessarily have to be a lawyer. Seek somebody who creates contracts for a living. Not all people that create contracts are lawyers. Some people are highly skilled in navigating and creating contracts, okay? And you may have one of those friends or family members. So seek them for advice. Have them review the documents with you, okay? Now, one of the things he points out is that, and I'm talking about Mr. Anonymous again, is that the fact that the mortgage documents, the warranty deed, the trust deed, the joint tenancy deed, are never filed with the Register of Deeds together. That's an issue, because now you can't prove that a promissory note ever fucking existed without them suing you for breach of payment, okay? They're never going to bring that original note back into the court. It's never going to happen, All right. And this is one of the things that they use to their benefit, but it also works to your benefit too. Should they try to foreclose on you, they're admitting that you gave them something of value. Okay. So you upheld your end of the deal. You gave them something of value. And unbeknownst to you, they can do a number of things with that note. They can trade that note. They can convert that note. They can sell that note. Okay. And when they alter the original intent of the purpose of the note, unbeknownst to you, they void out any obligation you may have had in the past. Remember, it started out as a promissory note. However, if it was traded without your authorization and authority, are you liable for it? The new holder of the note, where is the contract between you and them? It doesn't exist, okay? This wasn't bearer paper, remember. Bearer paper means whoever holds the paper is entitled to whatever the shares are worth written on the instrument, okay? This was a promissory note. And most often, and most of the cases that I've looked at as far as acquiring the loan, the alleged loan, and I err on the side of caution when I say loan, because loan is really the wrong word. If there was a loan that actually happened, it was you loaning your original source issue value, your original value source issue to them, okay? Because your signature is the value. Well, how do we validate that? Well, we go back and we look at who carries the primary active degree of fault for all debts. U.S. Bankruptcy Act of 1933, Section 101, number 11 declares that the American people are the creditors and that the United States is the original obligor or debtor, and that the signatures of the American people are to be used as credit, and that the state franchises of the United States of America, Inc., DBA, United States, state of Indiana, state of Arizona, state of Ohio, don't give a shit what state of it is, and their trustees, being the DBA, doing business as the Secretary of Treasury of Puerto Rico, the custodian alien property holder, the comptroller of the currency, etc., are to discharge all debts, period. Okay? And the location of the United States is found in UCC subsection 9307, okay, H, where it says the United States is located in the District of Columbia. Title 11 USC subsection 109, who may be a debtor? A, only a person that resides or has a domicile, a place of business or property in the United States, or a municipality may be a debtor. So understanding these facts helps you out tremendously. So they take your note, they convert it into an order to pay. When they converted it to an order to pay, a thing in legal land happens called destroyed. They destroyed the note, okay? Now, a lot of times what the bank will say, instead of claiming that they destroyed it, they will say, we lost the note, Your Honor. We lost the note. We lost it. Well, lost to a common man means that somehow some bumbling idiot like Joe Biden was left with some very important documents and somehow they flew away in the wind when he wasn't paying a fucking attention, right? That's what the most common people infer lost to mean, but lost simply means that it was destroyed. And destroyed doesn't mean that it was burnt or shredded or wadded up or cut to pieces or used a blowtorch on. No. The word destroy means to alter for a purpose otherwise than what it was intended for, okay? So they altered the document. They converted it with verbiage, with language, into a completely different instrument. It takes a completely different form at this point, with different obligations, with different intent and purpose, okay? So when they take a promissory note and convert it from a promissory note to an order to pay, that order to pay has now changed and altered that instrument forever. It can never be reversed. It has been converted to something completely different. So it is no longer a promise to pay anymore. It's an order to pay. And what they did with it when they did that is they, in fact, got paid. In most instances, through the Federal Reserve extending its credit 10 times the value of your blank banker's endorsement on that promissory note. Okay? So let's fast forward a little bit. That's just kind of a brief synopsis. This is really all off the top of my head. This is stuff I was studying like 3 or 4 years ago. And I'm just kind of refreshing my memory of it because of all the questions that are coming. There's more to it than just that. I want you to ask yourself this question. And keep this in your mind because it's going to make sense here in a little bit. 1, can you give something away that you don't own? The question is, can you give something away that you don't own? And if that question is no, you're on the right track. If you're uncertain of it, you need to do a little bit of soul searching, okay? The second question becomes, can I pledge something I don't own? Can I pledge my neighbor's car to borrow $10,000 from Ted down the street? Can I pledge some neighbor's car? The answer to that is no, okay? So for all you people out there that didn't think that you bought the real estate and property with the promissory note, you're sadly mistaken. Because the fact of the matter is, you absolutely paid for it in full with the original source issue, the original value, as being the source issuer of the issue, and that issue being the promissory note. After 72 hours in commercial law, they don't send that note back to you. They accepted that note as a tender of payment. Okay? It was an offer of tendering of payment. Now, here's where they get you. They take your note and they call you back. And because you don't get the mortgage paperwork in its entirety and take it home where you can review it, because you're so excited. They're telling you, hey, if you don't hurry up and sign this, there's 3 more buyers down the road. They've all put offers on it. You're the lucky one here today. So all we need you to do is initial here, sign here, poke your finger, put a drop of blood here. That's not really what happens, but pretty fucking close when you think about it. You get done signing all this stuff and you never realize to think that you just pledged real estate and property as collateral for a mortgage based upon a fictitious loan that doesn't exist. Okay? Now, in doing so, there are some things that you should realize. We already covered 2 of them. 1, you can't give away something you don't own. Okay, that's a fact. That's law. You can't give away what you don't own. I don't own this earth. The Heavenly Father created it. I don't have the ability to give it away. It's not mine to give. Okay? And secondly, I can't pledge the earth to anything, for anything, to anyone, for anyone. I can't do it because I didn't create it. I don't own it. It's not mine. Okay? If you didn't own the real estate and property. And remember, real estate and property are different than land. Real estate and property are of the legal realm, the fictional realm, okay? Because they recognize and realize that they can't give away God's great creation either. They can't buy it. They can't sell it. They can't give it away. They can't bequeath it to anybody. And they know this in the legal society. So for people to say, oh, God's law doesn't matter, natural law doesn't matter, you're off your rocker, nature's God doesn't matter, is felonious, because there is a clear-cut difference between legal and lawful. And legal sure likes to imitate lawful, but I'll tell you right now, it's the furthest thing from being lawful in most instances. So you managed to pledge your real estate and property. Why do I say that it was yours? Well, again, you can't give away something you don't already own. And how would you own it if you haven't rightfully paid for it? But wait, you did pay for it. You did pay for it. You created value, new money in the economy. The banker, the trustee, took off with your original security that was an over-the-counter security with your wet ink signature, unqualified signature, mind you. And they ran to the Federal Reserve and said, hey, you guys mind extending your credit 10 times the value of this note? It's got a wet ink signature. The Federal Reserve looks at it and goes, ooh, yeah, blank banker's endorsement, a private pledge? Oh, for some life source energy, and all I got to do is extend you guys some credit. Tell you what, we'll go ahead and extend you 10 times the value of that note. In credit, mind you, not Federal Reserve notes, not pesos, not rubles, not emeralds, not diamonds, not gold, just credit. Simple ledger entries, double bookkeeping entries, nothing special, okay? When you pledged, and make no mistake about it, you did this on your own by not reading. You pledged on a UCC1 financing statement the real estate and property for a mortgage. Now it gives them the ability to shop around that note and sell it to an investor. Okay, this trustee has got a bunch of what they call tranchers, and they are going to shop around to find the highest payer, the one who's going to give them the most bang for their buck for that note. Okay, this is what they call the AAA rated mortgage-backed security scam, and it is a scam, make no fucking mistake about it. Because the second that the note and the mortgage are separated, they're void. In ab initio, as though they were never created and they never exist. When the mortgage and the note aren't together at closing, it's as though there was never a mortgage at all. Okay? So, then you have the, oh, my mind's going to slip on me here. Retail installment agreement, okay? So in your mortgage package, there's these retail installment agreements, okay? And when you realize what's really going on, they were supposed to provide you, through the Truth in Lending Act, some very, very specific documents, okay? Actual functional documents. And instead what they gave you was HUD overview papers. They didn't actually give you the real HUD documents, which gives you the ability to rescind your signature at any time. Even during foreclosure, you can do this, all right? Under the Truth in Lending Act, and the fact that the HUD paperwork was never properly given to you. They were supposed to give you the HUD contracts that explained to you that you could terminate your signature and do a rescission of signature, and they never gave that document to you. They gave you HUD fluff papers, all right? They gave you documents, paperwork from HUD that has a lot of verbiage on there, but they did not give you the right documents that they were supposed to by law. So you got the H8 and the H9 that they were supposed to give you. They never gave you that. Nope. So they're in breach. That's false and misleading deceptive trade practices, ladies and gentlemen. They are concealing information from you that they are required by law to provide to you. All right? I'm kind of going into a deep explanation of all this shit that I don't know that it's really necessary, because it really boils down to there never was a loan. There are no, the mortgage is not in arrears, and the bank refuses to provide the 1098. That's really what it boils down to. But I'm going into deeper detail so you can really comprehend how you can combat this bullshit. And maybe it'll help you wrap your head around it a little bit more. You are an undisclosed, unnamed, unknown, third-party beneficiary to the transaction. Okay? And they never explain that to you. They never disclose that to you. And proof of that is the fact that the note was never registered with the Register of Deeds the same time the warranty deed was registered. Those things should have been filed together at the same fucking time before they went shopping them around and trying to sell them to investors and tranchers and everybody else through retail installment agreements and the whole ball of fucking wax. That should have been done. So for future people who get involved in this nonsense, take that documentation of the promissory note home with you. Go sign it, use your own fucking notaries. All right? Sign an initial where you need to sign, do all that great gravy shit, and then take it in to the Register of Deeds and file that motherfucking note. Excuse me, it's not file. Proper words here. Words have power. record that note with an affidavit attached to it, okay, allonge to it. You don't actually have to physically attach it, but you want the affidavit with the promissory note, okay, submitted for recording purposes on the land record, okay, because it deals with real estate and property, okay. If they're going to say, well, we can't do it until you get a warranty deed or whatever, tell them the warranty deeds are coming. It's not an issue. I can bring the warranty deed tomorrow, but for now, I just need these put on record. These are going to the bank. It's already been approved. Everything's all good and gravy, baby. But I want this note on record so I can draw a reference to it later that it's a promissory note, and what they have here is a converted instrument into an order to pay, which liberates the alleged debtor. Now you have the evidence that the note and the mortgage have been separated if the bank can't produce both of them simultaneously in the court. Okay. You have the evidence that they've separated them, and what does that do? It voids the mortgage. There never was a mortgage if they don't have the note and the mortgage together simultaneously. So during a foreclosure, there are really three questions. Or three statements that should be made. There never was a loan. All the documents that the bank is bringing forward into the court are forgeries, okay? That the mortgage is not in arrears, and that the bank refuses to provide the 1098, which would give rise to them having standing in the court. Not to shut it down. Now, there's some people on here that say, oh, well, you're leaving a bunch of money on the table. Okay, I agree with you. I wasn't going to go forward and explain any of that stuff because it takes a long time to really rattle all that shit off. But for those people that are interested about what the comments were made and validation of what they said, they're correct. There's a bunch of money left on the table. All kinds of money. It's not money in the aspect of silver and gold. It's credits on account on a ledger that are being left on the table. And he's fucking right about that. And I'm not going to deny that. I just didn't want to take the time to explain it, because why I tell people the things I tell them is because they're simple remedies to help them in their time of need, where they're about to get kicked out on the street with 2 dogs, 3 kids, and live in their van down by the river. And it's really hard. And it's heartbreaking to know that these things are transpiring all because people don't have a common knowledge and conception of what's really happening with the bank and in the court. So I give these little simple remedies that anybody could do. A 3-year-old can do what I'm telling you guys to do. So this is just a little deeper explanation of how it actually works. Through my research and knowledge, and through other people who have mentored me for years and years and years, showing me this stuff. So on the warranty deed, again, you're not an owner. You're a tenant. Okay, well, there'd be a joint tenancy deed, quit claim deed, a general warranty deed, a special grant deed. I don't give a shit what it says at the top of the paper. You are never the owner. You'll always be the tenant, okay? That's where the unlawful conversion comes into place, when the title insurance company converts your information into an all-caps nom de guerre, which is an unregistered, false and fictitious business name that isn't recognized by the Secretary of State, and it sure the fuck isn't your full legal name. Okay, go look at any warranty deed. You will never see the full name, such as Derek Chaton Gonzalez on it. It might be Derek S. Gonzalez, it might just be Derek Gonzalez, it might be D. Chaton Gonzalez, but it will never read Derek Chaton Gonzalez, uppercase, lowercase, showing the man owning the real estate and property. Never happened. Nope. You have to correct that. You can correct that record. You can do a quick claim deed on it, correct the record, all that good fun jazz. But that's one issue. The second issue is that the mortgage, title insurance company actually is in breach of contract and breach of trust. Okay. They told you that the real estate and property was free from any encumbrances. Okay, but it wasn't. All right, and we're going to get back to the point that you're just a tenant, because that's an important piece to all this. This is where your remedy comes back in the form of compensation. So the title insurance company is there to ensure that it's free from encumbrances. They go back and do a detailed check of all the prior owners, and they do what is called a chain of title check, and they trace it all the way back. In most instances, only like, I don't know, 30 to 60 years. But if they really did their job right, they would trace it back all the way back to the original land patent. Okay? Most companies don't do that. I do know some really kick-ass fucking people that are in the title insurance business, and they do, in fact, do their due diligence and tie it all the way back to the original land patent. But for the majority of them, they just half-assed it. They go back 30 to 60 years because, let's be honest, how many times has a title insurance company ever been sued? It's not very often that happens, because many people fail to read and understand what it is. They're just happy to have the keys and be able to be in their new house, and scrub their butt in a new tub. All right, let's be honest about it. That's how most people feel about it. They don't care. They just know that they're benefiting from signing a few papers and that they've got a $1,300 mortgage every month, and they're elated about that. Okay, they never really do any due diligence until things get hard and they get in a pinch. So, knowing that the title insurance company is in breach of contract and breach of trust, you have to understand why. Because they guaranteed that the real estate property, lot, block, parcel ID number, zone improvement project number, address, and easement came with no liens or encumbrances. But that is wrong. That is absolutely wrong. Because if it was free of all liens and any encumbrances, ladies and gentlemen, you wouldn't be subject to a property tax. That's a fact, Jack. You can take that to the bank, cash it all fucking day long in the tune and the amount of 3 times the amount of your alleged mortgage every fucking day of the week. And they will cut you a check and settle with you outside of court, guaranteed, so long as you know how to execute due process of law on the private administrative side of things. They will cut you a fucking check every day of the fucking week. You have to get a hold of the federal government and ask them how much of the real estate, lot, block, parcel ID number, zone improvement project number, address, and easement is attached to the national debt, and that you want a full payoff quote for it. They'll send it to you, believe it or not. Okay? I actually go, oh, sure. What's the address again? It's 515 856 Q Street, Okay, location? Okay, it's at this state, this township, on this lot, on this block, on this parcel number, connected to this zip code. Oh, no problem. We'll send that payoff quote to you right away. You said you want to pay it off in full? Yes, I want the full payoff quote. I want the full payoff quote. Because what the title insurance company doesn't tell you, and maybe they don't know this, a lot of them are very compartmentalized. That's why I quit holding so much animosity towards agents and agency, because a lot of them are just blind. They don't know these things. They were never taught this stuff, and naturally, they just want to do their job. They're so compartmentalized. I just got one job here, Derek. That is to push the enter button every 5 minutes. That's what I do. 5 minutes on the fucking dot. I hit enter. I don't know why I do it. It's just what I've been told to do, and that's what I do. All right? I don't know anything else about what you're talking about, buddy. Okay, that's cool. I'm good with that. Remember, you have a duty to know. You have a duty to know your job. And for the people that just want to sit there and push the button every 5 minutes as they're told to do, that's all the further they'll ever evolve in their career. They will be a button pusher, a paid employee the rest of their life, with no hope of ever gaining any promotions or things of that nature. All right, because they just don't have interest in what their actual job is. And because of that, they'll always remain a button pusher, which is fine for most people. Most people just want to clock in at 8 o'clock, punch out at 5, have a beer at 5:30, and think they're fucking free and believe that the American dream is alive and well. They never question anything. They do what they are said or told to do, and they listen to the boob tube because CNN, Fox, MSN, ABC, NBC would never fucking lie to them. All right, and that's okay. There are people out there like that, and I'm just fine with it. I've accepted it. I have no animosity towards them. Just don't get in my way when I'm spitting knowledge and truth and facts. Because it will cost you. So, you can bring a claim against the title insurance company for that. Because they lied, they're in breach of trust, they're in breach of contract. They told you that it was free and clear of all encumbrances, and they failed to tell you that there's a federal super top secret lien held by the federal government tying everything to the national bankruptcy. All real estate and property is mortgaged. And Colonel Mandel House told us all that, okay? Some people say that Mandel House didn't say that. Whether he did or didn't say it, that saying that is quoted by everybody is spot the fuck on. So I find it hard to believe that he didn't say that, considering that at one point he was part of the Federal Reserve before he was advising Woodrow Wilson, by the way. So we've covered the conveyance, the false and fictitious conveyance of language, the unlawful conversion of your warranty deed into an unknown, unregistered, unidentified, assumed business name, which if you want to correct that, just go get the DBA and the same name that is on the warranty deed and claim that shit. All right? Tie it to your warranty deed. Now you own the DBA. The DBA has as an asset the warranty deed. Now you can claim it that way. Because in foreclosures, that's really what the lawyer's doing. He's coming in going, and they're not saying this outright. Your Honor, the unknown, unnamed, unregistered beneficiary is nowhere to be found. And we've got a duty to protect the trust. And we're going to come in on behalf of the unknown, unverified, undisclosed beneficiary of this trust matter. And we're going to go ahead and foreclose in the interest of the beneficiary. That's what they're doing. All the meanwhile, you don't realize that you're the unknown, unnamed, unverified beneficiary of the whole kit and fucking caboodle because of your original source issue that you gave. 433 Cemetery Lot under the coroner's office. I'm not sure what you're talking about, brother, but I'll look into it or speak to you about it. So, we've covered a number of the things that they do. What's the remedy? Well, the remedy is coming forward and letting them know who you are, what your interest is in it. So when they foreclose, because this whole topic got started on a gal who said, look, they're still sending me 1098s like 6 years, 5 years after they foreclosed on me. And they're showing me, a value, a peso symbol with numeric value afterwards to the tune of tens of thousands of dollars. And they're sending it to me. I can't remember what she said, every month, every quarter, every 6 months, whatever. What does that mean exactly? You're the undisclosed, unknown, unverified third-party beneficiary, okay, or beneficiary who has interest in said mortgage. You see, when they foreclosed, nobody ever had the frame of mind to ask them for the original note back. The original note has value, ladies and gentlemen. It's money. Money in the false and fictitious realm of the monetary system that we have. The second thing that nobody had the frame of mind to ask for during the foreclosure was every fucking payment they made plus interest. Now, people go, oh, well, Derek, that's just not how it works. We're in breach of the contract and they get their cake and they get to eat the ice cream too. If you believe that, then I don't want to hear you bitching. You got exactly what you believe to be true. So you have no room to bitch at all. But if you'll go do a little bit of due diligence, you will quickly realize that you have maintenance that you have done on that house. You painted the house. You reshingled the house. You mowed the yard. You planted new plants. You put new shrubs in. You planted trees. You watered the grass. You paid the bills. You re-insulated it. You drywalled it. You did whatever you did to that house to make it a nicer house, all while you were a tenant, which means you have interest in said real estate and property. You have a collateralized interest, or what can be collateralized interest in the house. You have an agricultural lien for the yard work and maintenance and upkeep and mowing the yard and planting the trees and taking care of the bird feeder and everything else. You have an agricultural lien interest in it. You have a mechanics lien interest in said real estate and property. Okay. But nobody ever thinks about these things. Nobody ever protects their interests, their sweat equity and labor that they've put into the real estate and property. And because of that, you are a real party in interest. Point blank and simple. I wish I had a better way of explaining it, and I hope you guys are understanding what I'm saying. They're running away with your life source energy, all under the guise that you own something that you really never owned. You were never an owner on that warranty deed, ladies and gentlemen. You took care of bank's property, and then the bank decided one day you were in arrears. Now, wait a minute. The only way you can be in arrears, well, there isn't a way. There isn't a way you can be in arrears. Listen to me and listen to me really fucking good, okay? The reason that you cannot be in arrears is because it's an impossibility. The reason that it's an impossibility is because the mortgage, the note, the mortgage is not due in owing until maturity. That could be 30 years, 35 years, 40 years down the road. But it sure the fuck ain't today, is it, Scooter? All right? So now what do you got? You got a claim against the bank for defamation of character, breach of trust, breach of contract. They provided false and fictitious statements before the court, bringing fraud upon the court in an egregious attempt to, one, conceal information from you, and two, extort you. They tried to steal your real estate and property, okay? Under the guise that there were arrears. There's no arrears, Your Honor, because the note's not due and owing until maturity, and that motherfucking note ain't due for 35 fucking years. Period. End of fucking story. I don't have to show you that I have an escrow set up, that I've been making payments, so at the end of 35 years, I assure these people that I can pay it, although it's a really good idea to set up an escrow and make your payments into that account, okay? But when they go to foreclose on you and they don't have the grounds or the standing for doing it, you have a cause of action against them. And for 3 times whatever the fuck they're trying to steal from you. And guess what? Ladies and gentlemen, if you can explain it, you will prevail. Pretty fucking simple. Your Honor, they don't have any standing here. I'm going to go ahead and bring a counterclaim for 3 times the value of the fucking note. You watch how quickly them lawyers meet you outside the courthouse, say, hey, we'd like to offer you a check. And, we hope that this doesn't insult your intelligence for our nefarious activity. We'd like to cut you a check for twice the value of the house. Don't get greedy and go, oh, well, Derek told me I can get 3 times. Remember, an offering of tendering a payment made and refused liberates the debtor. So you be wise when they make an equitable offer that's substantial and prudently reasonable. Maybe you should take it. Oh, you mean this cancels any obligations I'd have with you and puts another $165,000 in my bank? Perfect. I like that deal. Thank you very much. How about those rights, titles, and interest you made from selling my private intellectual property by converting the note from a promissory note into an order to pay, monetizing it 10 times its value, and then turning around and sourcing it out to tranchers who have invested in it as a AAA-rated mortgage-backed security? Where's my 8.9% on that? I'd sure like a piece of that pie, too. It's all business, baby. That's what it's all about. So I hope that explains it a little better. The other day, what I put out there was just to help people that were in dire straits in the middle of a foreclosure and about not to have a house anymore, or a roof over their head. For those of you that haven't got into the foreclosure situation yet, and trust me, the foreclosure mills are up and running, baby. They're going to be running full fucking bore, full steam ahead real fucking soon. This whole COVID nonsense, if you've noticed, you don't hear anything about it anymore. That means that shit is over. That boat has sailed. They have done fleeced all those fucking pandemic bonds. They've liquidated that new form of currency, pumped it into the economy, if you will, bolstered everything up so that when the bubbles pop, they'll be even worse down the road. But those foreclosure mills are a real deal, and they're getting ready to fire back up again. So I hope you take to heart, there never was a loan. All the documents that the bankster's lawyer are bringing forward are forgeries. They're always forgeries. And the mortgage was never in arrears and is not in arrears. And that the bank refuses to produce the 1098. And I claim that to be a remedy because, well, it's been done a fuck ton of times. And most recently, about a few weeks ago, it was executed. And the lawyer immediately took tail, ran out of the fucking court, told the bank, hey, do not move against these people. This is closed. Close this shit. Do not go back in there with that guy. we will not prevail. So you take that for what it's worth. I just gave you guys a little more icing on top of the cake as far as agricultural lien, mechanics lien, keep all the receipts you do for maintenance and upkeep on the interior, paint, drywall, all that shit. Because if you don't own it, guess what? You're entitled to all of that maintenance, all of that upkeep. Keep your fucking receipts. If you're in a dire straits of a foreclosure, you say, you know what? I'll agree with the foreclosure. Just go ahead and pay me that, $250,000 for my time, my labor, my energy, and maintenance and upkeep and everything else. An agricultural lien doesn't necessarily have to be recorded, ladies and gentlemen. You need to go look at your agricultural maps within your state and find out what liens need to be recorded and what liens do not need to be recorded. All right. Agricultural lien takes precedent over any other lien. It's the number uno lien anyone can have is an agricultural lien. So take it for what it's worth. I hope that helps you out a little bit. Yes, in the middle of a foreclosure, I would absolutely say, hey, I conditionally accept your offer so long as you're willing to give me my original note back, plus interest, and all my payments back. You don't get your cake and eat your ice cream too in this world. You get one or the fucking other, Bubba. That's just how this works. I get all my payments back. I get my maintenance back. I get my labor back. I get all these receipts where I had people come and tune up this place and make it nicer, and insulate it and drywall it and do electrical work and everything else. I get all that back. You don't get all my sweat equity without fucking paying for it, motherfucker. There ain't no free rides at Derek's house. It don't work that way. It's ass, cash, or grass. Ain't nobody riding for free, especially a lying, looting fucking lawyer or a fucking plundering banker. You motherfuckers definitely don't get passes. All right? So I love y'all. I hope that helps you out, and we'll talk to you soon.